Xavier Becerra, the Attorney General of California, has announced his intention to press charges against any employer that notifies federal agents of their immigration status.
Okay, let me make sure I tell you what I said, or I try to repeat what I said. There are new laws in place in California now in 2018, with the advent of 2018. I mentioned two of them specifically, AB 450 and SB 54. AB 450 in particular deals with the workplace in particular, and how we go about treating the information about the workplace and employees at the workplace by employers, such that we try to protect the privacy interests of people who work there, and that we're not sharing information in ways that would violate the rights, the privacy rights of those individuals, and the ability of folks to work free of coercion and free of fear.
So he is packaging this as privacy for the worker. But don't employers have every right to do a background check to see if you have committed any felonies? How is illegally crossing a border and forcing your citizenship onto a country, how is that not a crime?
At the workplace. And so what we're trying to just make sure is that employers are aware that this is 2018.
And it's current year. Well, I'm going to have to cut the clip there because my editing program will not play the rest of this clip, despite it being functional in VLC and in Windows Media Player. Now let's take a look at the Senate bill itself, Senate Bill number 54, Chapter 495. Scrolling down just a little bit here, existing law provides that when there is a reason to believe that a person arrested for a violation of specified controlled substance provisions may not be a citizen of the United States, the arresting agency shall notify the appropriate agency of the United States having charge of deportation matters. This bill would repeal these provisions. So, does the state of California have a right to ignore federal law? The answer is no. The Supremacy Clause of the United States Constitution, Article 6, Clause 2, establishes that the Constitution, federal laws made pursuant to it, and treaties made under its authority constitute the supreme law of the land. There is also the case of McCulloch versus Maryland, a case from almost 200 years ago, where the state of Maryland had attempted to impede the operation of a branch of the Second Bank of the United States by imposing a tax on all notes of banks not chartered in Maryland. The decision that was made was that the states are inferior in regards to power and authority to the federal government. Well, I'm going to go ahead and end the video there. I intended for this to be about a 6-minute long video. That's what I've been shooting for lately. But I don't want to ramble for 3 minutes, and I don't want to flood you with useless information. But a link to both the bill text and the Wikipedia page where I read about McCulloch versus Maryland is in the description if you want to check it out for yourself. And I will be live with an early edition of my typical live stream on the channel if you want to come by, say hello, send me some links, anything like that. But anyway, I'll see you all later.